The promo code BONES at LifeLock.com. Terms apply.
There are a lot of people still in shock in Wichita, Kansas, where that flight that crashed Wednesday night near Washington took off from.
Our arms are extended in unlimited compassion, care, and love.
That's from a vigil in Wichita. Fox's Madeline Rivera reports from Reagan National Airport.
Many of the victims have still not yet been identified, but we do know that several of them were figure skaters, members of the Skating Club of Boston, coaches Evgenia Shishkova and Vadim Naumov, and teenage skaters Spencer Lane and Gina Hahn. Coaches Naumov and Shishkova were reportedly married. The group was returning from the U.S. Figure Skating Championships.
And unrelated to all that, the figure skating world is also mourning the death of a legend, two-time Olympic champion Dick Button.
1984 U.S. Olympic gold medal figure skater Scott Hamilton called Dick Button one of the most important figures in our sport. U.S. Figure Skating said the two-time Olympic champion's pioneering style and award-winning television commentary revolutionized figure skating. Dick Button, a winner of 5 consecutive world championships, who won gold medals for the United States at the Winter Games of 1948 and 1952, died Thursday at age 95. Former U.S. Olympic skater and current broadcaster Johnny Weir said Dick Button told it like it was, even when his opinion was not a popular one. Jared Max, Fox News.
A condemned killer only has a few hours left to live.
The Supreme Court rejected an appeal from South Carolina inmate Marion Bowman, and afterwards he decided not to request clemency from the governor. The 44-year-old said he didn't want to spend the rest of his life in prison for a murder he has always insisted he did not commit. Bowman's scheduled to die Friday night by lethal injection for the 2001 killing of a friend found dead in her burning car. Carmen Roberts, Fox News.
On Wall Street, stock futures are rising before the opening bell this hour. I'm Dave Anthony. This is
You're
Fox
listening
News.
to Lawrence County's Heritage Station. This is 105.3, 95.3, WDXE.
That's us, WDXE. It's time for Stan Pierchoski with Bulletproof Estate Planning. How are you, Stan?
I'm fine, Jeff. Good morning.
Well, it's been a whole week.
It has been a whole week.
Yeah, have you had a busy week? You always
did.
Busy. You're
I
always
did.
busy.
I did.
You're always busy, man.
We are always busy. And it was a good week. We had our seminar last Saturday.
Oh, that's right. Fill us in. How did that go?
Right here at WLX, Country Cafe in the back. Almost standing room only.
Oh, wow.
Used up all the tables, and I still had some chairs. But, yeah, we had over 50 people here.
That's fantastic.
So much so I had to bring a PA system. Remember I was asking you about if I could tap into the one. I got to look at the one that's back there, and I probably could have, but not at the last minute. So
Yeah.
So anyway.
So it worked out for you?
It did. Had a lot of good folks, good questions, a lot of engagement, and some very interesting topics came up. You know, a lot of the ones, you know, like you were talking about earlier, like a lot of folks in a position where they got a loved one in care.
Yes.
And not sure what to do, stuff like that.
Right.
But the next one coming up, you know, we do them about every other month. Next one coming up was March the 22nd. That's a Saturday again. It seems like the Saturday ones are the popular ones. So
Yeah.
we used to do them on Thursdays, but we kind of. Anyway, March the 22nd, it's at 10 o'clock. It was going to be at the American Legion in Pulaski.
Okay.
We've done it over there once before. And, you know, the theater is usually where we do them, but there's so much going on at the theater these days, it's hard to work it in. But they've got a great venue over there. They remodeled it not too long ago, and it's beautiful.
Yeah.
I don't have to carry my big screen TV over there because I got several on the wall, so I just can tap right into them. So
that's awesome.
That is nice. So I noticed you guys have a big screen TV back here now.
We do.
I didn't expect it when I came in and I saw it on the wall and thought, well, maybe I'll use that next time.
Yeah, I'm not sure. I haven't utilized it myself, but yeah, it's back there. It sure is. It sure is. You've got a couple of great venues there for doing what you do, and people can take advantage of that. When you have these seminars, that's pretty good. So mark that one down, March 22nd.
I'll bring that up again at the end of the hour. But
sure.
You know, I was coming in, I was listening to the show, and I know you got a caller.
Yeah.
And the caller made a comment. I didn't catch, I think I maybe just caught the last 10 minutes of the show because we're coming from Pulaski. When it comes Weekly Creek, it kind of takes a while till it actually comes in. But anyway, I heard that they call it, referring to the term of decanting.
Decanting.
And there is such a term, decanting a trust. And it's really something that we adopted in 2012 when we adopted our Uniform Trust Code. And the decanting is, you know, to put it, it gets its name from what you can do. You know, it's technically if you have a trust, and it's a trust that you have, there's certain things you cannot amend. That doesn't necessarily mean an irrevocable trust. That's maybe I'll start with that first. And an irrevocable trust does not mean you can't revoke it.
Okay.
I mean,
It's kind of deceptive, isn't it?
I mean, would it surprise you if I said you can revoke an irrevocable trust? And I'm sure you would say yes.
Yes.
Say, boy, that sounds like a bunch of lawyer double talk. But it's not. I mean, it's an unfortunate name. The trust code is very clear on how to revoke an irrevocable trust. So if the question is asked, what's the difference between a revocable trust and an irrevocable trust? The answer is not one's revocable and the other one's not. The answer is this. A revocable trust or an irrevocable trust, you, the maker of the trust, the trustor, cannot be the beneficiary. And that's what gives us the creditor protection we always talk about.
Right.
With the revocable living trust, you're all three. You're the maker of the trust. You're the trustee. You're the beneficiary.
Okay. Right.
An irrevocable trust, but you can revoke it. Now, that being said, there are areas of irrevocable trust that you can't change because that's what makes it work, and that's why it is an irrevocable trust in the first place.
Okay.
But you can make modifications. Now, when I often say in our asset protection trust, which is an irrevocable trust, you can't change how it works, but you can change how property goes at death. Let's say you have the 3 kids, right?
Yes.
So you get on the outs with one and say, you know what, I'm going to leave you 0 and the other 2 50%, right? Yeah. You want to make a change.
Yeah. Hard to imagine, but it could happen.
You can make that change for how it gets distributed after death. Okay. Mm-hmm. But if you want to change how it works, I mean, you're hard pressed to do that. So what could happen that you would need to make a change? And usually, almost always, it's some kind of change in the law. Now, if you have a trust and a change in the law comes up, and it affects the working of your trust. Because remember, the couple of trusts that we do are not the only kind of trusts that are out there. There's a lot of taxing trusts, IRS type trusts, that I don't even deal with. But you can have one where there's a change necessary to be made, and you, the trustor, the maker of the trust, cannot make the change. So when we adopted the Uniform Trust Code, we also adopted a position called trust protector. And trust protector is a grand thing. A lot of states have it. I'm glad we adopted it because it appoints an individual who can modify and make changes to a trust without having to go to court. But the trust protector has to be an independent and uninterested person, and usually a professional. So I name myself as trust protector in all my trusts, but it doesn't have to be me, but it does need to be somebody like me. Somebody who knows and understands the family and what they want to do with their trust, the overall purpose of what they're trying to accomplish, somebody that understands trust law and a professional. So it needs to be somebody like me.
Sure.
Now, what I can do, I mean, I have no control over property, but what I can do is through things like fill vacancies, I can modify the trust to comport with the law. Now, when we do that, what we really do is we create a whole new trust, and we take this trust and we kind of decant it into the new trust that comports with the law. So that's where it gets its name. You kind of think of it as pouring one glass, get a glass of wine that needs to be changed, and you're pouring it into another glass, and the change gets accomplished when you do that. So you're decanting one trust into another, and that is allowed. And it's a narrow window of what you can do when you decant. Okay. And it's basically geared toward, if somebody has a trust and a change in law happens, their trust should not be null and void because of that. You know what I mean? You should have an opportunity to make that comply with law.
Interesting.
Kind of has to do with the ex post facto concept. You can't make a change in law that reaches backward in time. But if you have a trust and they change the law on something, you're stuck with it not complying with that law. So you need an opportunity. Due process requires you get an opportunity to kind of fix the mistake.
Wow.
Fix the change.
I would say this is fairly rare.
It is rare. I've done it once.
Yeah, I would say it's pretty rare.
A couple of times it came up, but there's usually something else to do that's a little more less cumbersome.
Yeah.
It is rare. I mean, I participate in a lot of estate planning forums. I actually run the Tennessee forum for the Tennessee attorneys, but it comes every now and then. I see it come up, so it gets done occasionally. But it's by far not it's an exception rather than a rule. Yeah. So, but it's a way to do it without having to go to court. That was really the whole purpose of it.
Cool. So now we know a little bit about it.
So you can get into some real weeds when you talk about decanting. So. But that is she's correct. She read about it. That is an actual term.
Yeah.
We have some of those terms are self-descriptive and some not so much. We talk about a pour over will, which is something similar.
Well, you want to explain that one to me?
The pour over will is what goes with the trust, and it basically says, "Hey, I got this trust. I funded the trust. I put all my property into this trust. My intent was to put everything I own in this trust. If there's anything I forgot, neglected, or otherwise didn't do, this will wills it to the trust.
Oh, okay.
So it pours into the trust. In other words, a will doesn't say, well, this goes to my wife, this goes to my kids. There's only one beneficiary of a pour will, and that is the trust itself. So
okay.
It says anything that's not in the trust, this sends it to the trust.
Okay.
Remember, we want everything to avoid probate. But the pour of a will is a probate action, but at least it is an abbreviated probate action. It happens pretty quickly.
Okay.
Anyway.
Interesting.
Gets technical.
Yep. See, I was already forming another question.
Go ahead.
Because I'm like, wait a minute.
You're on a roll.
Wait a minute. If we got a trust, we don't need a will. Even if it's a pour over will, we don't need a will.
I say that every time. I'll say to people, I say, hey, did you come to my seminar? And they say, yeah. And I said, I beat up on wills really bad. Didn't I know. And they said, yes, you did. And I said, well, now I want to write one for you. So what's up with that, right? It is an ancillary document. It does work well with trust, because I have dealt with a lot of trusts that people have brought me, maybe from the late 90s, where a lot of trust mills kind of come into town and have a workshop, and people write the trust, and then they give them the trust and says, congratulations, you got a trust, but they don't really inform them much that now you got to move your property into it. And so they take it home and they put it on the shelf, and then their heirs bring the trust to me, kind of say, what do we do?
Yeah.
And we start looking, and we find out there's a lot of stuff that was never put into the trust.
Yeah.
Because they didn't know. I mean, I'm assuming they weren't advised on that. I doubt that people just neglected to do it. I think they just weren't properly advised. And so we can put it in the trust, but we have to do it through that will.
Unless you are well versed in all the things that could happen, you're likely to forget something.
Oh my gosh, yeah. I mean, it doesn't actually. Funding the trust, that doesn't happen as often as you might think, because most people have the same basic kind of assets. They have a piece of real property, which is a deed, which I put in for them. I take the approach that I will put in, if you come to me and say, I want to do a trust, let's say a revocable living trust, you and Teresa, I will put into it everything I can put into it for you, like your real estate, your house. I'll redeed the property to the trust, and you'll sign that, and that'll be in there. I'll put your stuff into the trust, what I call your stuff, your pots, your pans, your tables, your chairs, all your personal property that's untitled. Including vehicles and boats. Okay, that's just a single document, which is assignment of personal property. It puts it all in. Property you own by possession, I can put in.
Yeah.
Now, really, the only thing left, that I haven't put in for you, is something that you usually have and you have a contract with a third party, like a bank.
Yeah.
And so you have a savings account, a checking account, a CD account, an Edward Jones account, whatever, something in the posture with a financial institution, right?
Yes.
Now, you have a contract with a bank, and I'm not on that contract. It's Jeff and Teresa with Bank of Frank Ewing, right?
Right.
Stan Pierchoski's not a party.
Yeah.
So I can't go in there and move your your account into the trust, because if I do, they'll show me the door. They'll say, what authority do you have to move Jeff's trust, to do anything with that? Yeah. I can't. So, but what I do, so there is that you have to do yourself. Yes. You have to go do that. But we talk about that at great length of what it takes to do that. I will prepare the documentation and the trust plan that they will ask for. They'll want you to prove that there is a trust, but you want to prove to them there is a trust without disclosing the personal information in the trust.
Right.
And so there's a thing called a certificate of trust that the legislator created that's for that very purpose. And they'll ask for that. And so you give it to them, they make a copy, that makes them happy. Then they'll move the thing in. You have to sign the documents, and you and Teresa have to sign the documents. And now your bank account is in the trust. But I can't do it for you. But what I can do is hound you and call you in 30 days and say, hey, or Alex would, and say, hey, Mr. Jeff, did you get those bank accounts moved in the trust yet?
That stuff
and
done?
If you say, well, I've been busy at the radio, and Teresa's got a honey-do list, and, it's coming up on spring, and then she'll call you again in 30 days and say, just following up. If 2 or 3 30-day reminders go by, then she brings it to my attention. Yeah. And I'll call you and say, all right.
You go to the principal's office.
Well, not really, but I will say, look, Jeff, the stuff that's not in the trust is not in the trust, which means it's going to have to go through probate. Now, we got the pour-over will, but my goal is that the pour-over will is a waste of paper and a waste of ink. I want it to not be used. It's just a plan B, right? Yeah. I said, plan A is get everything into it. And I'll say, there's something we can do to help you put this in? Do you need me to go to the bank with you?
Yeah, hold my hand.
I tell the women I'll hold their hand. I'm not going to hold yours, but I'll go with you, and we'll sing Kumbaya or whatever we need to do and get it done. Because if it's not there, it's not there. And I heard somebody say that you were master at procrastinating, so I guess that's where it's coming from.
I was going to say, I would get the 30-day call, I'd get the 60-day call, and sometime in the next year I'd get it done.
No, and then something will happen. And the heirs will come to me and said, "Hey, how come this property wasn't in the trust?" And, and then I have to ratchet out.
I'm really working on it though, Stan. I'm working on it. I'm working on not being a procrastinator.
I gotcha. So me too.
There we go.
You're in good company. Yeah. Everybody does it. I swear to God.
Yeah.
So, but well, I forget how we got into that.
I don't know.
I think we thrashed it out pretty good.
We've our conversations have just led in so many directions regarding all of this stuff, and I've learned a lot. In fact, I'm pretty much ready to do it myself. I'm just kidding.
All right.
Wow. Ready to take the bar?
You
So,
listened.
Yeah, I've been listening.
Oh, so you're the one.
I've been listening. Yeah.
Hey,
no.
I wasn't able to tell, but I know just before the end of your last show, I heard LB talking about getting qualified for TennCare. Was he talking about a particular situation? Because I didn't catch that part. And I know you brought up that we helped your father and stuff like that.
Yeah, I don't remember exactly what he said. I was telling him he needed to get his stuff together, and he said that he had some issues that he had to work out. And I said, well, putting it off, like we do. So I don't know. I don't remember specifically what he said, okay. But anyway.
Well, that was the thing I noticed at the seminar. I got a lot of questions about people who have loved ones already in care.
Yeah.
And that's a pretty scary thought for them because they don't know what to do.
Yeah.
Or they don't know what they can do. Had somebody that raised their hand during the seminar, and of course I like to keep the questions toward the end. And anyway, they brought up the question that they've gone to the internet. That's the authority, right? If it's on the internet, it's got to be true, right?
Yeah.
He goes to the internet. He talked to the guy down the street. He talked to some people, and so-and-so's Aunt Gertrude's in care, and there's just nothing you can do. We're going to lose everything. We're just SOL. They're going to get it all, and that's all there is to it. Because even the facility told them, just keep paying us till there's nothing left,
right?
And then he'll qualify, and that's true. I mean, if you qualify, because once you're indigent, I mean, you'll qualify by default.
Yeah.
Right. You have anything. So, but I mean, that's not the case. I mean, we touched on a little bit with your father-in-law, but I mean, there's a ton of options where you don't have to lose anything, or sometimes lose as little as possible. It depends on whether you're single or married at the time, but not of the rules we can follow. But you can protect a ton of property, and there's nowhere in the statute does it say you have to spend it on care.
Yeah, yeah.
We talk about that stuff all the time, and here at this show.
Sure.
And I welcome people to call in. I guess we didn't give the number, but you can call in with an experience. Maybe we can thrash it out a little bit. Hopefully, it's not an experience where it's already all past and can't do anything about it.
I think that's probably one of the key things that's out there, or the key problems is so much misinformation regarding this, because people are telling their experiences, and then someone will take that experience and apply it to them and think, well, there's nothing I can do. This is going to happen. We're going to lose it all. There's so many things, and there's so much you can do if you do it ahead of time.
I'm going to go through one.
Okay.
That scenario that I hear a lot about.
All right.
And it's not that I don't think it's misinformation nonetheless. I think it's just don't know.
Yeah.
I mean, misinformation implies that you're doing it intentionally wrong, right?
Right. Well,
I don't know that.
Or misunderstanding.
I don't think it's necessarily that most of the time. I think it's just lack of understanding. Just don't know.
Sure.
Or if you hear the same thing for years and years, and you think that's what it is.
Yeah, we just assume what we've heard is right.
That's right.
So I have a quick question.
Yeah, we'll treat you like a caller. Pull the mic up.
About that, you would think that these facilities would have a dedicated specialist on staff that would help with that would direct someone to the right place, the lawyer or something like that. Is that even the case?
Well, you would think that, and I don't know if you would think that or not, but I mean, they do have usually a department that they have at least one individual, maybe more. Sometimes, usually somebody that's dedicated to help people apply for TennCare.
Yeah.
And that's not really where I have the issue. I know they don't ever refer you to an attorney. I mean, I've gotten referrals from facilities, but that's not typically what they're supposed to do.
Right.
But some of them do. Some of them have seen what we do, and somebody comes in and they know they need help, and so they kind of refer them. I don't know if that's runs afoul of what their policy is or not, but we do get referrals that way. But here's kind of what happens. I hear this a lot. Okay. Let me kind of go through it.
Okay.
And again, before I say it, I'm not picking on facilities. You know what I mean? I think this is just what they know, and it's not entirely correct, but they're not. I don't insinuate for 1 second that they have any evil intent by saying this. Okay, by saying this to people. But here's what I often hear happens: somebody goes in. Okay, and you're there, and maybe you're in your Medicaid window where they're paying, and you're not financially bleeding to death because Medicare is paying. But eventually, Medicare paying comes to an end. And we don't know when it is. We just know it's somewhere less than 100 days, right?
Yeah.
Or 100 days. So when they're coming up on the ending of the Medicare paying, they will approach the family and say, hey, Medicare is going to run out here in such and such a time. The bill is $10,000 a month. How do you expect to pay for this person?
Yeah.
And so that's when the panic kind of sets in, usually. But then they'll have the person that helps do the applications, who will say something affected. We'll file the application for you, the TennCare application.
Yeah.
It's a 16-page application, and they will. But here's kind of what happens. It's a very intrusive application, 16 pages long. It asks everything you can possibly think of about your health and everything you can possibly think about your income and your resources. Resources meaning the stuff you own, assets. And so it'll say something like, Aunt Gertrude's in care. They'll sit down with her and say, Miss Aunt Gertrude, do you own a house? Yes, I own a house. And then put down the real estate that they own, okay? Do you have any money in the bank? Yes, I got $50,000 in the bank. They'll write it. I mean, you have to be truthful in the application.
Sure,
right?
sure.
So it's full disclosure. So we got $50,000 in the bank. I have a couple CDs, just the normal stuff people have, right? You enlist it. It asks about all that stuff, and you put it into the application. Then you send it in, okay? And they do. They'll send it in for you. And they sometimes they proudly proclaim they'll do it for free.
Yeah. And
they will. But once they send it in, I'm telling you, it doesn't take a PhD to understand that they're going to deny it for being over-resourced. Okay?
Yeah.
You have too much property you can afford to pay for care, right?
Yeah.
And they'll deny it. And then they'll come to the person and say, we sent it in, Miss Gertrude, and it got denied. So just keep paying our bill at $10,000 a month. And when you whittle it down to when you have nothing left, then we'll apply again, and then you should be eligible. And that will probably work. But the problem is now you have nothing.
Yeah.
You've spent it all on the care. And now, it doesn't have to be that way. I don't know how that got started, but it must have been decades ago.
Yeah.
Because everybody thinks if you have to do what they call spend down, you have to spend it on care. And I defy anybody, attorney or expert, to show me where in the TennCare Act you have to spend it on care. And you can't because it's not there. I've looked. It's not there. It actually suggests other things to do with it, the statute. Other ways to protect your property. So that is a way to do it. And I think they just think that's the way it's to be done.
Yeah.
I mean, they didn't get educated in this field, so they don't know. They just don't know. And it is a way, but it's not the only way, and I don't think it's a very good way. Because wouldn't it be better to save everything that you own and get eligible?
Yes.
I mean, that's what we try to do.
It's the whole point.
Yeah, and there's ways to do that. And without getting into all those options, there are a lot of different options to do that. And you can protect it. And now, in that same scenario, I want to do a sub scenario out of that, and that is when. Many times I hear that when people are in a facility, they'll ask them, do you have a home? Or what is called the primary residence. Okay?
Yes.
You mean in real estate. You can have two kinds of real property as far as TennCare is concerned. One is your primary residence, and the other is other real estate. And the other real estate is defined as not contiguous to the primary, and there's a third-party property owner in between your two pieces of property. So they don't share a border, right? But anything contiguous to your primary residence is considered the primary residence.
Yes.
Okay. Now, they will often say, "Hey, don't worry about your house; it's protected." Okay. We don't even have to put it on the application. We put it on the application, but we don't have to do anything. You don't worry about your home. It's okay. It's protected. Now, if you're in this field, I could write a book on people who lose their home.
Yes.
To care. So. What's happening there. Here's what happens with this, and here's where I have an objection to the terms or what they tell patients. And so they'll say your house is protected. I object to the term protected. It's more of a deferral. What it is, the house is a countable asset. And you've heard me on many times on this show talk about countable assets. And if you have too many countable assets, you're just not eligible.
Right.
Well, your primary residence is a countable asset. Now, I often say this: if you have trouble with the word countable, insert the words available for cost of care asset.
Yes.
That's the same thing. So your primary residence is a countable asset. So let's just say it's nice round numbers. Let's say your primary residence worth $100,000.
Right.
You can't get anything worth $100,000 these days, but that's a nice, easy one to do in your head, right?
Right.
How are you ever going to qualify for TennCare? Because you're always going to be $98,000 over-resourced, right?
Yeah.
Because you're allowed to have $2,000 of accountable assets.
Right.
So it is actually an excluded asset. The actual term is excluded. And what that means is this. If you're in care, you got this, let's say you're otherwise eligible except for this house that you have, right? Let's just make it easy.
Yeah.
And they'll let you take the house and take it out of the countable assets column and put it in the excluded assets column. Okay, and now they're not going to use the numbers to calculate your countable assets because you would have just lowered them by $100,000 by recategorizing it, right?
Yes.
So now let's say you're below the level and you're ready, you're able to get care, and they give it to you.
Yep.
And they pay for your care.
Yes.
$10,000 a month, $120 as of now, $120,000 a year. You stay there the average 3.6 years, whatever. At your death, or the patient's death, right? There's something called the TennCare Estate Recovery Act, which means they're allowed to go after anything in your estate. Now let's think about this for a second. You're a real estate man, so you should follow this very clearly. Mm-hmm. Remember the house.
Yep.
It didn't go anywhere. You still own it.
Yep.
They just did not use it against you for eligibility purposes.
Right.
And now they go after the house to the tune of whatever they paid. So if it's a $100,000 house and you got a $200,000 bill over the 3 years, which is not too hard to rack up,
right.
It consumes the entire house. And so when they tell you the house is protected, that's not the whole story. That's a real Paul Harvey moment there. We need to hear the rest of the story.
Rest of the story. That's right.
And so they need to know that. Now, there's a way to prevent estate recovery and keep that house. We do it all the time. And there's a way to do that, but that is not it. Now, if you're married, okay, we'll pick on Jeff. Jeff is in the nursing home, and his wife is living at home. She's healthy. He's the one in care.
Not so healthy.
You're in care. And you pass, on the same scenario, they'll exclude the house, and then you pass away. Well, and if Teresa's still living in that house, God bless them, they will not go after the house until after she dies.
Yeah.
But they will after she dies, and they will accept, whether she goes into care or not, they will file a claim on your house, and that's how they get the house. I mean, people say, "Oh, this little old lady, she had to sign her house over, and she lost her house." It usually doesn't work that way. They get it through the TennCare Act after death. That's how you lose the house. Some people say they signed the house over. If that ever happens, or the nursing home made them do that. The nursing home doesn't make you do anything. You go to the nursing home and they say, "Here's the bill. If you can't pay us, we don't have to take care of you." Right? I mean, it's kind of like free market society, right?
Right.
You want our services, you got to pay for it, and I don't blame them for that. That's if they take care of somebody, they're entitled to be compensated.
Right.
They don't take your house for that. They just say, "Sorry, we're not going to admit you because you can't pay us." So I've heard of people saying, in order to guarantee payment to them, they sign over the house because you can't give them $10,000 of your house. You know what I mean?
Yeah. Well, the nursing home never takes a house.
No,
it's the system. The TennCare system.
Nursing home always gets paid. If you're either private paying, and if you qualify for TennCare, TennCare pays them. They always get paid. I mean, so they don't go taking stuff. So that's kind of a misnomer.
Yeah.
But the way they get it is through the TennCare Act. I mean, the State Recovery Act, and that is something that is when we plan. That is something one of the two biggest things we look out for the most is estate recovery. And there is a way to avoid estate recovery, because the theory is if you pass away with any indicia of ownership in real property, it is subject to the act.
Yeah.
Husband and wife own property is right of survivorship in Tennessee, but that isn't ownership at death. Even though it all vests with the survivor, you have that ownership at death, okay, and that makes you subject to it.
I'll throw a monkey wrench question into that scenario. You used me and Teresa, for instance. Let's say
you can use me and Tammy if you want.
I'm in. Let's just say I'm in your scenario. I'm being cared for, and I'm being paid for by TennCare because bless our hearts we don't own anything but our house, and have no money other than that. My wife's living in the house, and then I go on to glory, and Teresa's still living in the house. Okay. Then she does a real smart thing maybe and fixes a trust.
Okay.
Can she transfer that house asset and all her assets into a trust and escape this after the fact?
She can't.
That's a weird one, I know.
She can, but if you have racked up a bill at your death, they'll put a lien on the house. And now the house has a lien on it. So she still owns it, but she has an indebted.
Has a lien on it. Okay.
And if she can move it into the trust, but the lien goes with it. So you really haven't fixed it. You haven't fixed the problem with you.
So we hadn't solved the problem there. Right. Okay. It just made me think. I went, well, what could she do with it after my passing or whatever? So anyway, she's still in the same boat.
And now a lot of people will say, well, let's sell the house.
Yeah.
You can do that.
You can.
But the house is an excluded asset. So there's some advantage to moving it in the excluded column. We just don't want to leave it there. We just don't want it to be there when you pass away. Because if you have any indicia of ownership, you're subject to the act, so we don't want to have ownership at the time of death.
Right. So
there's some advantage to doing that. But here's the kicker. The house is an excluded asset. The money you get when you sell it is not.
Right.
So you got a $100,000 house. It's excluded.
Yeah.
You sell it for $100,000, you got a pile of cash. That is not. That is a pure countable asset. That is not. You can't put in the excluded concept. So now you have to deal with that. Now you're over-resourced again.
Yeah. Yeah.
So we take advantage of the exclusion, but there's more we do to it. We take advantage of it to get the person eligible quickly, because we can, if you got not any big deal at all to have a $300,000, $400,000, $500,000 piece for primary residence these days. So we can lower our assets by that much, with a stroke of a pen by excluding it. But then we're going to do something somewhere down the line. It's kind of a simple solution, but we're going to do something to make sure that it's not available to the Thin-Care Act. I mean, I can get into it, but it gets it gets kind of heavy.
Yeah. And I've said this several times during our conversations, Stan, that and I was of this mindset until multiple conversations with you, or learning a little better, and that is that that a trust is something only the wealthy people do.
And the rich people do trust. Right?
Yeah, only rich people have these trusts. Well, what the heck are you talking about? And it's not. That's not the case.
Oh, it's not.
It's not the case at all.
The size of the estate should never be the deal breaker.
Right.
And for one good reason is this. Sometimes we'll talk about celebrity estates because you hear about them. When Tom, Dick, and Harry out there pass away, you never hear much about those estates, or you don't know the facts.
Right.
But somebody famous passes away and they get into a what match in court over inheritance and stuff. You hear all about it. Right?
Oh yeah.
So say you got $100 million estate, which and they have a battle in court and it costs them $30 million.
Yeah.
Well, they still got $70 million that they divide among people, right?
Yeah, we feel sorry for those folks.
If you are, really, if you're in our boat, you still suffer the cost of a court fight.
Yeah.
So if you have less of an estate, it's more important that what you have go to the people it's supposed to go to and not get consumed by some procedure that can drain it.
Yeah.
I mean, if you've got a $100 million estate, you can afford some leakage, right?
Yeah.
But if you don't, then you can't. If you're like us, you can't afford much of it.
Yeah, you don't want to leak too much at all,
or you don't have anything to leave them.
That's right.
I mean, that's a reason why it may be more important to do it if you're not a rich person.
Yeah.
And now rich people, you'd be surprised how many of them don't get around to doing it. Celebrities too.
I would
Celebrities
so.
too.
Yeah.
I mean, and they get crazy. Every now and then I'll do a fun show on my radio show that I do out in Nashville where I talk about odd things that are in wills and stuff like that.
Yeah.
Some of it's pretty bizarre.
That would be an interesting thing to discuss.
Because if you put it in a will or a trust, I mean, it's enforceable. You can get it done. Now, some things are just bizarre. Like somebody had a ton of money, and he didn't have any heirs, or he didn't like his heirs. I can't remember. And he just picked like 70 names. Oh, it was in Portugal, Lisbon, and he just picked 70 names out of the Lisbon phone book.
Oh, wow.
And said they get an equal share of his thing something like 50 years after my death. So almost 100 years later, some 70 people inheriting a fair amount of money just out of the blue. I mean, why?
Why would you do
there was
that?
There was no discussion as to why. That's what was in the will. He didn't explain why. He just said it was
that's just what he wanted to do.
Just strange stuff like that.
Yeah.
There was one I thought it was cool. It was out of Canada. He was actually an attorney. When he passed away in his will, he said his entire estate goes to the person in Canada that has the most babies in the next 10-year period, starting at the day of my death.
Oh, really?
Now, I don't think everybody ran out and tried to win that. I mean, I don't think so. But at the end of 10 years, there was actually two people that tied. They both had 10 children.
Oh, wow.
In that time period, and they tied and they split that estate.
Split the estate.
I mean, why? I don't know. It just makes you laugh a little bit. One of my favorites was Janis Joplin. She, well, of course, that was some time ago. She passed away young in the 60s, but she said to take $25,000, which in the 60s would have been a fair amount of money.
Yeah.
And she wanted all her friends to just have a big party.
A big party.
A big drunk. Now, one of my favorite ones, and I think I may have mentioned this before, was I can't remember who it was.
Yeah.
But he said he's going to leave his estate to his wife, but only if she gets remarried, which seems backwards, doesn't it?
It does seem backwards.
And then he said in his will, because then there will be at least one person who mourned my death.
That's funny.
That is funny.
Oh, my gosh.
There's at least one person who wished I wasn't dead because he got remarried to his wife. It's like, talk about the last word, right?
Oh, my gosh. That kind of reminds me, if you don't mind, two guys playing golf and the funeral procession's going by. And one of them says, hold up just a minute. And he takes his hat off, puts his hand, and they're standing on the green, but the procession's going by. And his partner says, well, did you know that person? He said, yeah, I was married to her for I was married to her for 20 years.
Oh, wow.
Didn't want to miss his round of golf.
Oh, wow.
That's bad. That's bad.
Okay, so now I guess we thrashed that out. So now what do you want to talk about?
I don't know. Stan. We can take phone calls for sure. 766-9393 is the number, and we've got, if you got questions for Stan, I will remind you that Stan Pierchoski Law Practice is in Pulaski, Tennessee.
It is
on the square next to the Star Theater right there. You can't miss him in a beautiful square downtown Pulaski, Tennessee, and Stan Pierchoski Estate. Planning, estate law, and we call it bulletproof estate planning here. And
it's the name of the show,
yeah, is the name of the show. And the reason that is because he can set you up where your assets are protected, and that's what this is about, protected after your passing, and you make sure your things go the way you want them to go. Which is important. It's something everybody's got to think about. We're only passing through this life one time.
I think so, but again, it's very procrastinated.
Yeah.
I get it.
Yeah.
I often tell the story that, I started, this is a second career for me, and I started practicing law in 2002.
Yeah.
And like 7 years later, I wrote my first will.
Oh, wow.
Which is pretty embarrassing, I'm a practicing attorney, and I never got around to it.
Yeah.
And it gets even worse. So I'm kind of wearing my heart on my sleeve here. It gets even worse. My wife and I did this will about 8 o'clock or 8:30 at night before we flew away on a vacation where we left our 3 minor kids with Grandma.
Yeah.
So we just got under the wire. Right?
Oh, wow.
We just did. Wow. If you're procrastinated, don't beat yourself up. You're in good company. Everybody. It's just common.
Yeah.
It's common.
Yeah.
Now I think I want to follow up on something. Last week, I think, if you remember, we had a 10-car case. It's in process.
Yeah.
And if you remember, I said they approved, but then they messed up the start date, and so we appealed the start date.
Okay.
And, was hanging out there. They have so much time on an appeal. Like within 90 days, they got to tell us when the appeal is. And we were getting pretty far into that. And they reached out to us and said, hey, we're delaying the appeal because the applicant has a power of attorney that names her husband. And all the documents that you sent us, now remember, this is after approval. Okay, we're all signed by the daughter, who's the next person in line as power of attorney, right?
Right. And
the daughter has signed all the stuff that they approved for. Now that on the appeal, they're saying, we need a resignation from the first POA that he's not the POA anymore. They're using the second one. And my response was, you mean the death certificate I sent you was not enough?
Yeah. Yeah.
And it was like, oh. Now, on their application, they ask, are you married?
Yeah.
And we said widowed. Now, widow's a legal term. It means.
You're right.
Anyway, so we fully let them know, and they delayed, and they said, this is going to delay the appeal. And I said, no, you don't make a mistake and then benefit from it. No, not with this firm.
Yeah.
I said, if you still got another 15 or 18 days or something like that on your 90 days, if you don't give me an appeal date by then I'm going to file something for untimely prosecution.
Yeah.
And they got back and they said, you're right, that person's dead. And
Yeah.
we'll accept the power of attorney by the next one in line.
Yeah.
So, well, that's big of you. Thanks.
That's a big. Oh my gosh.
And we got the appeal date. So actually, we got the appeal date, and we talked about it, and we canceled the appeal because they kind of folded on the issue. So.
Wow.
They gave us what we wanted. They gave us the start date we wanted because they did make a mistake on that. So.
Yeah.
But I mean, it's just you talked about. You said earlier, I heard you on when I was listening, driving in. I think LB said, how does anybody do it on their own? I mean, that's the kind of stuff you run into.
Yeah.
I mean, what are you going to do if you don't know what to do when they come up with that?
Yeah.
They do it all the time. I mean, I don't know if it's the attrition rate or the fact that if you call there, you never get the same person twice, or people come and go. I don't know what kind of training they get, but sure in much, whatever it is.
Yeah.
You get up to the legal department, you get a little more done. You get a little more competency. But I mean, you're dealing with that, and they just make these decisions out of I don't know where they come from, and so you have to appeal it.
Yeah, I'm telling you, if you had to fill out that application for a loved one. I don't even like, going to the doctor and having to fill out the new document that you go to the doctor. Is this your first time here? Well, I need you to fill out this. Mm-hmm. I hate doing that.
As you know, that application is 16 pages long.
Yeah. So when I said that I don't know how people would do it on their own, they do, but they probably end up inevitably getting denied, and then you go through this whole process, and then that's what happens. And I've been totally impressed and with our conversations and knowing what I know, having personal experience with it, that you helping someone through that process, you don't send the application in until you know it's an approvable application, and they will approve it.
I mean, that's a model that we use, and I don't think how you can do any better.
Yeah.
If we don't send the application in until we're absolutely positive the person's eligible.
Yeah.
Because I often say this: you read the questions on the 16-page application. There's nothing in there that looks ominous.
Yeah.
You say, well, it looks pretty simple. I just answer them.
Yeah.
The problem you got to worry about, what do they do when they get the answers? That's where the knowledge comes in handy. So
right.
you're putting down, if you say, how much money you have in the bank, and you say, I got $20,000 in the bank. Well, I know exactly what they're going to do with that answer. That it goes into the eligibility calculation, right?
Right.
And they're going to, or whatever, or if they ask the question, have you ever given anything away in the last 5 months for less than fair market value?
Yeah.
The third question from the end is that one.
Yeah.
And if you say yes, and then there's another one that says what, when, how much, stuff like that.
Yeah.
I know exactly what they're going to do with that. I mean, that will disqualify you.
Yeah.
And so with too much money in the bank. So we don't just fill out the application like they kind of do when they give the service at the facility.
Yeah.
We don't put the answer in until we have the answer the way it's supposed to be. So if you got $20,000 in the bank, that's a countable asset, okay?
Yeah.
So what we'll do is take $20,000 and we'll turn it into a non-countable asset or a non-countable stream of income. Now we're going to ask the question, how much money in the bank? None, or less than $2,000, right?
Right.
Because we've altered it. We're not giving them misinformation. We're not hiding the ball with them.
Right.
Before we apply, we're modifying the asset to something that's not countable.
You're putting in a legalized process.
Sure. I mean,
yeah.
We recategorize it. What's amazing is the word, you hear people talk about the spend down. You got to spend down. And they apply the street vernacular definition to that. Like, so you got to go on some kind of spree and get rid of all your money. It's a legal term. It doesn't mean that. It means recategorize your property.
Yeah.
So we recategorize it from countable to non-countable. There's a lot of non-countable assets. So we turned it into a non-countable asset.
Yeah.
And now when we answer the question, how much money you got in the bank? None.
Yeah. Yeah.
If they say how much money, they don't ask how much money you have in a Medicaid compliant annuity, but if they did, we'd say $20,000. Yeah. Or they will say that because they'll ask for about a year of bank records, right?
Right.
And they'll look at the bank record and say, what happened to that $20,000 that came out of that bank on such and such day? And I said, well, I'm glad you asked. Let me tell you. We turned it into a Medicaid compliant annuity pursuant to the Deficit Reduction Act that we adopted in 2006. You know that thing. You know that thing that you've been working with. It's Medicaid compliant. It's an annuity. It's a single premium immediate annuity. It doesn't exceed the applicant's actuarial lifetime. Payments are all, it's irrevocable and unassignable, and every month the payments are the same. There's no balloon payment at the end. So it's Medicaid compliant according to the Act. So that's what we did with it.
Yeah.
And now it's no longer countable.
Yeah. Yeah.
And say, okay. And so when you do that with all the questions, you force them to approve. They have to approve because the person's eligible.
Yeah.
But what happens a lot, and I don't like to scare people with this, but it happens more often than it should, let me put it that way. You get some inappropriate denial, something they don't understand.
Yeah.
And they just say, I'm going to deny. And then when you call them and ask them, I don't know, a third of the time we get people that will discuss it with us and maybe get somewhere.
Yeah.
But I'd say more often than not, it's like, well, I already denied it. I said, well, I'd like to talk about it because I think it's an inappropriate denial. Well, you can appeal it. I got too much to do. And they can literally almost hang up on you and say, there's nothing, I'm not going to talk to you anymore. Just you can appeal it. That's your remedy. So we do, and we went on appeal. But but maybe we could cut to the chase a little earlier and fix a mistake that's here.
Yeah. It looks like it would work with you to do that more than
Well,
that.
I mean, it's like I say, there are some occasional, maybe a third,
Yeah.
that they'll talk to us and we'll educate them, and they'll listen and they'll say, "You're right. That's
You
right."
know, and we've said this many times, and you've said it several times here today. The $2,000 thing. A lot of people may be surprised to know that you cannot qualify for this care or this benefit or entitlement if you have more than $2,000 of assets.
No, more than $2,000 of countable assets.
Countable assets. Yeah.
The operative word is countable.
Countable.
Not 2,000, which
Yeah.
is everybody thinks it's not $2,000 to your name, which is how it's interpreted.
Right. So in the terms of countable assets, if you've done all things right, the most you can have that's a countable asset is $2,000. So if you have more than that, they're going to deny you.
That's right.
So
That's
even
exactly
if
right.
you have $2,000 in your checking account.
That's countable because it's available for the cost of care.
Right.
Yeah.
Or less than 2,000.
Right.
Now, let's ask a question. You know, that when people say that to me, or when I see that, I think to myself, all right, let me ask a legal question. If I can, and the statute's clear, I have to have less than $2,000 of countable assets. That's the limit.
Yeah.
If it's 2001, I'm ineligible.
Yeah.
So can I have $2,000 of countable assets and $500,000 in non-countable assets and still be eligible? Seems like a logic question. If you have countable assets, can you have a non-countable assets? The answer is yes.
Yep.
Okay, if I can have non-countable assets, can I have 2,000s of countable and $1 million in non-countable?
Yep.
The answer is yes, and you can apply and you'd be eligible. I mean, we do it every day.
Yeah.
My record's 2.8 million, and still getting eligible. So it's not $2,000 to your name. It's $2,000 of countable assets, and the key word is countable. It doesn't mean all that you have, which is that, and the street vernacular definition of spend down leads you to believe you've got to go spend the money, get rid of it.
all your
But
stuff.
you can't just go spending it or get rid of it, because if you try giving it away, they'll hammer you on the penalty period.
And I run into a lot, especially in the real estate world, where mom and dad deeded their property to the children so many years ago just to avoid this thing. And that's one way, but it's not a guaranteed way, because things can happen that's not expected. You might want to elaborate on that a little bit, if you know what I'm talking about.
Well, I don't know that I have enough time.
You may not.
But I'll tell you what, how about I put that off for next week?
Okay.
Because I want to ask you a question.
Okay.
And that might fill the 8 to 10 minutes we have left.
Okay.
Because you might be able to help me with this, because it deals with title insurance companies, and you
Okay.
deal with them a lot in the real estate world.
I do.
I have a client. Now, it's not so much a 10-care issue or anything like that, so maybe this will clean it up a little bit. And I haven't called them yet, but I think I know what they're doing, but I'm not entirely sure.
Okay.
His father passed this property to him. We were kind of pre-planning, but his father passed a piece of real estate to his son.
Okay.
By deed, and the father was still competent, no problem with that. And about 2 or 3 years ago,
Okay.
well, he passed away recently, and the son just decided to sell the property. Now, he sold it, and the day of closing, of course, now the buyer hired a title insurance company. I won't say which one, because I don't want to get my blood up, and I don't want to do that.
Yeah.
But the buyer has a title insurance company, and the day of closing, the title insurance company tells this seller that we're not going to give you the money. We're going to hold it for 6 months. And we also want all your brothers and sisters to sign a quitclaim deed saying they don't have any interest in this property. Now, let me rephrase the first part. Father deeded it to the son like 2 years ago.
Okay.
Now, the penalty period is not an issue. The person passed away. They weren't on 10 care or anything like that. So he deeded it to him. It was a gift, but he did deed it to him.
Right.
I can't get past the fact that complete ownership happened at that first deed.
Yeah.
And now, title insurance companies, here's what I think they're thinking. They're thinking, we're going to, and if they're thinking this, then what's magical about the 6 months? I don't know. But they're saying, we're not going to give you the money because if a claim surfaces, we want to be protected.
Yeah.
Now, he just passed away, and creditors' rights stay open for 12 months after death. So if you're going to do something for the dumb reason, then at least do it for the right time period, which is 12 months.
Yeah.
But so I'm going to call them and find out, because I can't figure out why there's this requirement other than just title insurance company wielding their power.
Well, to some degree, I think that's it. Now, I'm not an expert on title insurance. I'm not and we use title companies and attorneys to close all of our transactions because that's just a better, safer thing for me to do. I don't close any real estate deals myself. We hire people to do that, and we hire the title search companies to do what they do, title companies. I have noticed, I think, an overabundance of precaution sometimes on the title insurance end. You can get a title search and a title opinion,
right,
and that's one thing. But if you want to go beyond that and have title insurance, you're dealing with a title insurance company, and
that does not want to pay any claims,
and
so
they don't want to pay any claims.
Carve out any risk. That's
so
right.
they try to eliminate any and all risk on their on that. Even though you've got an attorney and a title company that's saying, "Well, it looks good. It looks good. It's okay here. It might be this, that, or the other. We'll see if we can get the title insurance to cover it." Okay, so that's what I see is just overabundance of caution sometimes. When something looks fairly plain, it's very simple to us. You know, we live in almost a Mayberry world here, where if you shake my hand, I'm going to take you that you're good. Right. But the title insurance world is nowhere near that.
That's right. Right.
They are overabundance in their precautions, and they want insurance.
Here's what I expect. Go ahead.
I was going to say now the buyer in this case, if he said, "Well, I don't really need title insurance. I don't want to pay that several $100s to have it," then that issue may go away.
I understand.
Does that make sense?
It does. Now, what I suspect I might run into, I'll press them. I'll say, "What is the purpose of this? I mean, explain it to me so I can explain it to the buyer. I mean, the seller." And they won't be able to. And I think the answer is going to be, "Well, that's just what we want done."
Yeah.
I want to say, what authority lets you do this to hold this person's money for 6 months? You know, first thing I'd say is, if you're going to do that, I'm going to demand 10% interest.
Yeah. Yeah.
I mean, because you're going to hang on to it and not give it to us, there's a cost to that, right? But why? Why? And they won't be able to tell me, "Well, that's just our policy, and that's all there is to it."
Yeah, it
or
could be.
somebody will say, "That's what the legal department told us to do." That's what will happen. And this happened once before, and I never got an answer. But my response was, "All right, then I'm advising my client heavily not to do it, to agree to it." And they said, "But the sale will fall through." I said, "That's what I'm advising them to do."
Yeah.
Just terminate the sale and say, "I'm not doing it."
Yeah, I mean, and they'd have that option.
Yep.
The other monkey wrench in this fan is if the buyer's getting financing, they're going to require title insurance.
Well, and that's what's going on. He got his money, and the title insurance, but still the title insurance is being unreasonable in their request.
Yeah.
It is to bring the siblings in to sign something. They have absolutely no legal claim. There's no vehicle that's even possible that they could raise a claim.
Yeah.
Now that the dad had already deeded it to the son. I mean, the time for them to raise a claim was then, and that has come and gone. And they want them to come and sign some stuff. And
well, you know, Stan, it's all your attorney's fault.
Probably. I mean, I'm sure it's coming from their legal department. Yeah. And I think it's just failing on the side of caution.
Yeah, it is.
But, I mean, it gets to the point of being unreasonable.
Yeah.
Now, I mean, if you wanted them to come in and sign it and they were okay signing it, I don't like it, but I could live with it. But holding this guy's money for 6 months, I mean, it's like a $500,000 house.
Yeah, yeah.
Holding his money. Now, and they darn sure better be compensating him with some sort of interest rate.
Yeah.
You know, I would not tolerate the 2 or 3%.
The title company could have the option of shopping an insurance with another title insurance company.
Getting different underwriters.
Get a different underwriter.
But I mean, they do this the day of closing, and you know, my buyer, my seller, pretty much said, I'm not in the real estate business, but we were dealing with him and his father. But he pretty much said, well. He said to himself, he said, "I don't really care. I'm just going to close anyway."
Yeah.
But it still bothers me that there's
kind of burn your saddle.
There's no basis behind it. There's no legal foundation for what they're asking, and that bothers me. You can't. You just wield this power, take it or leave it.
Yeah. Run into a lot of stuff.
Maybe more of us should say, "Okay, we'll leave it."
Yeah.
That's
go to a
what I
title.
would say for sure.
But you know, there's only a few title companies out there, and they just do whatever they want. And you know, banks have said this to me. They say, I get them in the corner, and they can't answer, and trying to say, "Well, it's just our policy."
Right. That
That's
happens.
That's the catch-all, right? It's just our policy.
Just our policy.
To which my response is, you are bound by your policy. I am not.
Yeah.
I'm advising my client to take his money out of your bank and put it in a bank that's reasonable. You are unreasonable.
Yeah.
And I'm not going to name a bank, but there's one that is prolific with that. And I mean, I don't think they care, but I don't know how they have any more patrons, because I know a lot of people that take it out before I even talk to them.
Yeah.
They go try to do anything, and it's no, you can't.
You can't do that. Yeah.
When these banks had changed names about a year or two ago, and their policies all changed with it. And I don't even see how they stay in business. But anyway, but as a patron, you can either patronize with them or not.
Yeah, that's right. We have the freedom to move it around. That's good.
Well, we're getting close.
Yeah, we are. We need to wind you up.
Yeah, sorry, you got me all wound up. Don't forget, next seminar, we just had one, so it's going to be March 22nd. That's about 2 months out. But it's never too early to RSVP for that.
Yeah, absolutely.
The American Legion there, it's at the American Legion in Pulaski. We call it Will's Trust in the Nursing Home. That's what we talk about. It's 10 o'clock on that Saturday. It's not too early to RSVP. And that venue holds about 80 or so, which should be enough. But, last one was over 50, so we never know.
Awesome, good.
But, if you have any questions about what I talk about on this show, of course, it's a call-in show. Don't forget, you can always do that.
Sure.
And make your question hypothetical if you don't want to, if you're worried about being too personal.
Yeah.
But if you have any questions, just call me at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222, or you can go to my website, which is estateplanstand.com, which is easy to get to.
Estate Plan Stands, and always interesting, Stan, always fun, and we'll revamp again and revisit again next Friday, good Lord willing.
Maybe we can talk more about the cabinet confirmation hearing.
Yeah, I would love to get in on that. That's been fun to watch.
It has been fun.
Fun to watch. All right. Well, God bless, buddy. Always fun to have you. It is almost 9 o'clock.
Yeah.
And we're going to turn the programming back over. But a good show, buddy.
Always a pleasure, Jeff. Thank you.
WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.
There are still a lot of questions after the mid-air collision near Washington, D.C. I'm Dave Anthony, Fox News, with a lot of focus on the Army Black Hawk helicopter that slammed into an American Airlines regional plane about to land. Defense Secretary Pete Hegseth tells Fox they don't know yet
who was talking, who was on the comms, who was